The reverberations are still being felt from the Supreme Court's recent decision to strike down Roe v. Wade. But where does the battle go next? The Supreme Court made its most dramatic intervention in American life in decades recently, when it rescinded the right to abortion that had stood for almost half a century. The decision sparked major demonstrations from people who support the right to terminate a pregnancy, and celebrations from those who see abortion as morally wrong. There are lots of questions about how the issue could affect November's midterm elections. Democrats hope the decision can galvanize voters, but it's just not certain that it will trump other issues like inflation and rising gas prices. But there's more to this question than party politics. Legally, where does the battle over abortion go now? One simple answer is it goes to the states. Now that the federal guarantee of a right to abortion has been struck down, it's up to states to make their own laws. 13 of the nation's states already had so-called trigger laws on the books. Trigger laws are laws that were passed with the purpose of banning or severely restricting abortion almost immediately if Roe were ever to fall. Some trigger laws take immediate effect, others come into force after 30 days. The New York Times noted that 9 states banned or severely restricted abortion on the very same day as the Supreme Court released its opinion. But women's health groups and other supporters of abortion rights have taken court action to at least postpone some of these bans. In one case in Louisiana, a judge injuncted the state's abortion ban until a hearing on July 8th. In other states, pro-abortion rights groups have contended that state constitutions protect the right to abortion, even if the Supreme Court now asserts that the US Constitution doesn't. But the legal battle doesn't stop there. It also encompasses other rights. Justice Samuel Alito, who wrote the majority opinion in the crucial case, noted that the US Constitution does not mention explicitly a right to abortion or a right to privacy. Still, Alito seemed cautious about extending this reasoning to other decisions. His Conservative colleague, Justice Clarence Thomas, wrote that the court should now consider, as he put it, correcting the error in 3 other landmark cases: Griswold, Lawrence, and Obergefell. Those cases respectively established a right to contraception, a right to sexual intimacy between adults of the same gender, and a right to same-sex marriage. Crucially, the first of them, Griswold, decided in 1965, found a right to privacy in the penumbras of the Constitution. It's this supposed right to privacy that provided the bedrock for the later cases, including Roe. If that right to privacy does not exist, the other rights that I just mentioned could go with it. It seems so inconceivable that the court would undercut those rights. But the abortion decision and the rationale underpinning it show just how high the stakes have become.